Many people are fighting cases that are not supposed to be in court. We advised in the previous episode, go to the funeral, see the parents, see the uncles, see the brothers, tell them you are owed. The simple law is, if anybody has written a will plus a codicil explaining how his properties will be distributed, you cannot go to that court saying he owed you. You will go to the ELC court if he owed you land. You will go to the commercial court or the civil court if the money was out of a contract or an agreement. To quote helicopter explainer, where we are dealing with a very simple but complex matter. Can you go to stop succession where there is a will because the person who died owes you anything? The person who has died in the earlier case, Biwott had not written a will. In this will, the dead person had a will. And that will never acknowledged that he owed anybody a will, a debt. So the person rushes to court to say, no, this man died. Then you are told, no, but there is a will and your name is not in this will. What you are claiming is not in this will. The courts will just tell you, no, go away. This is what faced the estate of His Excellency, Daniel Toroitich Arap Moi. Can you imagine? In the High Court of Kenya at Nairobi, Milimani Law Courts, Family Division, Succession Course number 405 of 2020. This Maestro Connections Health Systems Limited were owed money by His Excellency, the late second president of the Republic of Kenya. What was the ruling? They sued the executrix, Wakili, my good friend Jan Mohammed. What does it say? His Excellency Daniel Toroitich Arap Moi died on 4th of February 2020 at the Nairobi Hospital. He left a written will dated 15th November 2005 and a codicil dated 30th March 2010. So he had written the first will in 2005. He again wrote a codicil dated 30th March 2010. The codicil revokes the earlier will. The codicil is the last he wrote. In the will, he left LR number 24480/2, comprising of about 931 hectares, which he instructed that it be held by the trustees of Kabarak University in trust for the benefit of his 5 sons. That is Jonathan Kipkemboi Moi, Raymond Moi, John Mark Moi, Philip Moi, and Gideon Moi. Equally, during their lifetime and upon their death for the benefit of their progeny. In the codicil, he gave Kenya shillings 100 million to each of his daughters, Jennifer Chemtai Moi, Doris Chekoril Moi, and June Chebet Moi. The deceased appointed Zebrabanu Jan Mohammed as the executrix and trustee of the will. On 18th August 2020, she petitioned this court for the grant of probate of written will. The grant was issued on 9th of October 2020. The applicants, that is Maestro Connections Health Systems, filed an instant summons of the probate of the Constitution seeking the following orders: that pending the hearing and determination of this application, This Honorable Court do issue orders restraining the respondent, her agents, or anyone on her behalf from distributing the estate. She had been appointed and given the powers to deal with the property of President Daniel Arap Moi. Paragraph 12. The judge moves on to say, I have indicated in the foregoing that as far as this petition stands, LR number 12422 of 2019 is not one of the properties subject of the estate of the deceased. This is because it was not mentioned in the will or codicil, and it was not mentioned in the petition. Now that there is a question in ELC number 771 of 2016 regarding the ownership of the parcel, whether or not it belongs to the deceased, that question rightly belongs to that court. The court will not hear and determine it. I have also indicated that if it turns out that it belongs to the deceased and it was not part of this property petition, it will be the subject of an intestate succession. Until then, this court cannot be asked to set aside the 2.2 is 250 of amount related to the dispute in the ELC court in the instant petition. This court cannot be asked as it were to anticipate the outcome of that case. Similarly, the application cannot by this application halt the process of distribution of the estate of the deceased, which he provided for in his will and codicil. This is because the applicant has not been determined by the ELC court to be owed or its price of the value by the deceased. The application at this point cannot proceed. It moves on in all that I would like to say at this state is that when the respondent will seek the confirmation of that grant of probate, she will serve the protester who will formally file his protest to this application. Justice Mchelule of the Family Division, dated 16th day of November 2021, Justice Mchelule Agri is now a judge of the Court of Appeal. What is the law here? The simple law is, if anybody has written a will plus a codicil explaining how his properties will be distributed, you cannot go to that court saying he owed you. You will go to the ELC court if he owed you land. You will go to the commercial court or the civil court if the money was out of a contract or an agreement. Many people are fighting cases that are not supposed to be in court. We advised in the previous episode, go to the funeral, see the parents, see the uncles, see the brothers, tell them you are owed. They will sort out that matter. Trying to go to a succession court to stop, you'll fail. What are we learning? Nobody is above a succession dispute. We have seen it from Biuko Inange, a former minister in the office of the President Jomo Kenyatta. We have seen it in Biwott, Nicholas Biwott. We have seen it now in His Excellency President Daniel Arap Moi. Our advice: plan your death, manage your death, go to a lawyer and prepare how your properties will move away when you're dead. Wakili Dan Sanamari, always bringing it the way. Thank you very much.